Okay, I think we'll get started, and I expect that we'll probably have some other folks join us throughout, but we'll go ahead and get going. This is a webinar that is a part 2 of a previous webinar that we have already done. This is related to financial tips for your separation or divorce or your family law case. And I'm here today with Michelle Dellino from Dellino Law Group. And I'll let her introduce herself here again in just a couple of minutes. I just want to tell you who I am. My name is Melissa Rosenberg. I'm a licensed independent clinical social worker. I'm a therapist in private practice, working with clients in all stages of the divorce process, working with clients who are contemplating divorce, who are mid-divorce, or who are working on their next chapter post-divorce. So I work with people on their emotional barriers related to all of these stages and phases in supporting their path forward. But today I'm here to kind of help moderate this webinar and to help answer questions. So what's going to happen is Michelle's going to be talking for quite a bit about the financial aspects of the divorce process and tips and things to consider. And if you have questions that come up for you during the time of this webinar, please go ahead and ask those. We'd love to be able to answer them for you. You can put them in the Q&A section. At the bottom of the Zoom screen, there's a Q&A section. You can type your question into there. You can also put it in the chat. If you put it in the chat, it will only come to me. If you put it in the Q&A section, others may see it. So it's up to you how you want to ask the questions. But if you ask questions, we will answer as many of those as we can for you and hopefully just deliver you some great information today. So again, I'm Melissa and I'm here with Michelle Dellino from Dellino Law Group. Michelle, I'll let you introduce yourself for a minute here too.
Great, thanks, Melissa, and thanks to everyone for being here today. So like Melissa said, we're going to do is we're going to run through some financial basics if you're in divorce or family law case. And some of the things I talk about, I'm going to talk about today. I talked about last time, but I think some of them are important and you need a fundamental base understanding of what's going on. So a little bit about me. My name is Michelle Dellino. I'm the owner and managing attorney of Dellino Law Group. We are a family law firm in Seattle, Bellevue, and Greater Puget Sound. We handle cases all over Washington as well. So it's not just limited to that specific area, although most of our cases are in King, Pierce, Snohomish, Kitsap, and Thurston counties. We do appear in other counties as well. So our firm is really focused on being solutions-based. So if you've got a problem, we want to help you find your solution. That doesn't always look the same for everyone. Everyone's solution is found in a different way. And we try to figure out what's the best path for you by getting to know you, getting to know what your objectives are, getting to know what we can do to help you basically get there. And like I said, that's not the same for everyone. One thing that comes up over and over again, though, and I think that's extremely important is financials. And so I'm just going to kick it off by saying that financials are a huge, huge stressor for most people in divorce. Resources that sustain 2 households now have to sustain 1. And that can make you kind of wonder, how am I going to do that? I even find that a lot of people stay in a relationship because they think we can't afford to get divorced. Whether you're the person that thinks I can't afford to divide my 401k and I don't want to have to do that, or whether you're the person that maybe has been a stay-at-home parent and thinks I'm not going to be able to support myself. So what am I going to do? I have to stay in this marriage or relationship. So it's a very, very stressful thing. Adjusting to a new normal is one thing that financially has to happen in a divorce. And what that looks like, as I said before, is simply not the same for everyone. Sometimes having the help of an outside professional, a financial advisor, or a certified divorce financial analyst becomes necessary as part of a case. Not always, but sometimes it can be a very helpful thing as well. So that's sometimes that we will bring in someone like that on your case, or we might need to get valuations of assets. And we'll talk about that a little bit in a minute. The first thing I want to talk about is, what do you need? What documents do you need? And I talked about this last time, but it needs to be talked about again because not everyone was probably here last time. So we're doing a deep dive on financials. And where do you even start with that? What do you need if you're going to start a divorce or a family law case at all? And when do you need these documents? Let's talk about that. So if it's a divorce, get these things together in the beginning because your assets are going to be divided and they're going to be reviewed. And we need to know what they are. And we always ask our clients for them. But if you're doing this on your own, this is a good place to start. If you're in a family law case, like maybe you're thinking about adjusting your child support, or when your divorce was in the past, or maybe you're thinking about changing your parenting plan and that might change, who pays support or whatever. This is another time you might want to do that. Anytime that you're asking the court for any kind of financial relief, whether it's payment of child support, spousal maintenance, attorney fees, or even in your case, if you're asking for a guardian ad litem or parenting evaluator to be appointed, the court needs to see financials because they need to know what can you afford and how do I make this decision about who gets what. So that is when you need the information. What do you need? This is the big thing. There is a very basic list of documents that are a great starting point. And I'm going to lay it out for you here. First thing is 1 year of pay stubs. Some people will tell you 6 months. 6 months is a great starting point, but a whole year really captures a picture of what's going on and regular deductions. So a year of pay stubs. Second thing, if you can do a year of this, that's great, but 6 months is what's really needed. 6 months of all financial statements that you have. So when I say financial statements, what does that mean? It means bank accounts, retirement accounts, investment accounts, mortgage accounts, car loans, all of it. I would also recommend that you get your credit cards together, even though those are not really, some people will consider them not required under the local family law rules. Some people do consider it, and the credit cards are going to need to be considered. So whether it's a cash account, whether it's an investment account, whether it's a loan account, or whether it's a credit card like revolving credit, get it together. 6 months of those statements. You usually should download them from your computer if you can. Not everyone likes doing things that way, but if you can, the most effective way for you to do it is create a folder for each account. Label the statements, January 2021, February, whatever, and put together a year of statements, year to date too, not just like the whole last calendar year. So if this is going to be March, you would want to have current from like February of 2021 to February of 2022. That's another thing that gets confusing for people. Next thing you need after the pay stubs and the 6 months of statements, and the 6 months of statements, I should say, usually takes people, I would say, the most time to get that together. The next thing that you're going to need is your last 2 years of complete tax returns, not just a summary page, but complete returns. So personal returns, if you own a business, if you own more than 5% in any business, you're going to want to have the business return available as well. You need to include any W-2s, any 1099s that you might have received, but complete returns, all the pages, the whole thing. That's going to be extremely, extremely important. You're also going to want to have a list of any cash or assets that you might have in the home. So if you have money in a safe deposit box, if you have an expensive watch collection, if you have cash somewhere, some people keep cash in a safe at home, which is strange to some of us, but some normal to others. Make a list of those things at the time so you know what there was when you separate, because it can have a way of things disappearing later. Health savings account information is also another thing that you want. You want 6 months of statements from your HSA if you have one. Some people forget that and it gets left out, and that is a financial statement, but it's also a specific thing I like to call out. HSA statements, have 6 months of it together. You're going to be glad that you did. Next thing that you need are mortgage or line of credit statements. I mentioned that earlier as well, but it's worth noting that home equity line of credit, also you need to have that as well. Any student loan statements or other debt statements that you might not think of because they're in your name alone, you need those as well. And then any promissory notes for outstanding personal loans that anyone owes you or your spouse, you want to have those as well. So get all of those things together. It's the pay stubs, it's the statements, it's the cash, it's, the tax returns, and keep it in a folder. It's going to be the best thing that you can do. So you have a lot to log in and download. So get together all your information at the same time. And it's a good idea to create a sheet of all the accounts that you have, all the emails that you have. And then while you're at it, go in and update your personal information to passwords that you haven't used before, so your spouse doesn't know what they are. That's another good tip. Next thing to do, as we talk about basics, is set up your own accounts. Some people operate in a marriage or relationship where everything is joint. Other people don't. Other people might only have a few joint accounts and they already have separate accounts as well. If you're in a relationship where you've had only joint accounts, set up your own account, because post-separation, you're going to want your paychecks that went in the joint account before to start going in your own account. And it's going to be just easier to figure out what accounts are post-separation if you are spending out of your own account. It doesn't mean you might not transfer money into the joint account for community bills, but set up your own account. I can't tell you enough how useful it is. And also don't change or close accounts just because you set up new ones, because that can violate court orders. More about that later. Next thing, as far as basics, is monthly budget. So I'm an attorney, I'm not a financial planner, but part of what we do is we come up with what's called a financial declaration for you. And we need to know realistically to do that. What is your budget? How much money do you have? What are you spending your money on? And how's that going to look to the court? And what's that going to mean as far as what your needs are moving forward, whether it's for spousal support, child support expenses like childcare, camps, things like that. So we need to know what your budget is. You might be panicking about how you're going to be able to afford to live post-divorce, or how much you might have to pay your spouse so they can afford to live if they make less than you. All of these fears are totally normal. And so is feeling vulnerable about finances in the future. So what you need is a team behind you that understands that. So we will help you work on a budget. If you're doing this on your own, work on your budget. You'll be, again, glad you did. You need a new budget though. You don't need to just know what it's been like when you've been sharing expenses. Your budget will have to change and move to 2 households instead of 1. Expenses will change. Cost of living might change if you move. You'll be paying for food for less people. So maybe you have 4 people in your household and you're separating and it's going to just be you and the 2 kids. That's 3 people, not 4. So you're going to need to come up with a budget. Now, usually your legal team will work with you on that because it's going to go in your financial declaration. And this will help make sure that you have sufficient resources in settlement and you can plan to move ahead. But on your end, if you aren't working with anybody yet, or you're just thinking about what to do, start with these basics. Housing costs. And this is what your housing is going to be going forward. And if you're the person that doesn't pay the bills and you don't know how much the mortgage is, this is a good time to try and find out. So you'll want to have housing costs. Okay, if I'm living in the house and I'm going to stay living in the house and my spouse is going to move out, how much is the mortgage? Or if I'm living in the house now, but I'm going to move out and I have to rent a 3-bedroom house or townhouse or apartment, how much is that going to cost in the area that I want to be in? So that's your housing cost. Utilities. Which ones? Some people have no idea how much the utilities are. Figure out how much your utilities are. Figure out if you're moving, what your cable provider is going to be there and how much it's going to be. So you can estimate that, because some people will think, oh, I've been paying $99 a month for phone and internet. And then you don't realize, yeah, but I've been on a contract that we've had for a few years and gotten that renewed. And if I want new service, it's really going to be like $300 a month. So that's an important thing to know. You want to have realistically know what your budget is going to be. Next thing after utilities, and that, again, before I wrap up on utilities, water, sewer, garbage, electric. Does the house have gas? Do you also have to pay for gas? Do you live somewhere where there's a need for air conditioning? Is that going to increase your expenses? If so, you want to be aware of that if you're moving to an area where that wasn't the case before. Cell phone and internet, you can kind of lump those under utilities as well, even though they're not technically household utilities, but all those things are important for your budget. Then vehicle expenses. This is another big chunk of change for most people. You might have a loan payment on a car, and maybe it's the car you drive, but your spouse has been paying it, or maybe you're paying it for your spouse. You want to figure out what your loan payment is for the car that you're going to keep post-divorce. If you have 2 cars and one has a loan and one doesn't, figure out which one is your driver and which one you're going to keep, and then include that in your budget. Insurance. A lot of people don't realize, but you have to get new insurance when a case is final. So get a quote, figure out what's it going to cost for me to have, insurance. What are my premiums going to be for the same coverage I have now? So that's going to be important for you to figure out. A lot of people don't even realize that's a thing. Gas and maintenance is another thing. You need to figure out, am I going to be driving to work every day? Do I work from home? What's my gas budget? Some people never think about that until they get divorced. Maintenance, what's the average that you're going to spend for that routine oil change that you get every so often? What does that look like for you? And another thing to think about here too is if you don't have a car payment, even if you don't have a car payment, you're going to need to pay for tax, title, and licensing. I don't know about you, but one thing that always really irks me is how expensive tabs are in Washington. So especially if you have a newer car, that's considerable. It can be $1,000 or more a year. So that you need to take that into consideration as well in figuring out what your annual budget is. Next big chunk is children's expenses. Do your kids go to private school? If they do, what's the tuition there that you're going to be sharing in? You don't necessarily have to put down that you're paying half because you might not know yet, but it's a safe bet to say, here's what the annual tuition is, and I'm going to pay part of it. Next thing is childcare. Do you pay for monthly childcare? A lot of people have before and after care for their kids. Maybe it's YMCA, maybe it's, any number of things like that. Maybe it's kinder care, whatever it is, you need to know how much that is per month. So you can factor in how much you're going to pay. Another children's expense is out-of-pocket medical. What's that going to look like if your kid has regular ongoing medical needs that are not covered completely by insurance? What's the out-of-pocket cost? And then also extracurriculars. Is it normal that you're both going to be paying for swimming lessons, and that's $200 a month? Okay, you're going to pay part of that. So children's expenses is a big thing. Childcare is usually the biggest part of that, though. Monthly debt payments. This is another thing that comes in on a financial declaration, and a lot of people have no idea. So this is a good time to figure it out. What is the amount of the monthly payments that you make on student loans, any personal loans, so line of credit, anything like that, and credit cards? And also, too, another note, while you're going through divorce or family law action that involves finances, it's an expectation that you just pay the minimum payments. No court is going to, if you say my monthly budget is $5,000 a month because I'm paying $5,000 a month on my credit card, unless you have a really massive balance, no court's going to accept that as reasonable. If the monthly payment is $335 a month, not the $5,000 every month that you're putting on it, they're going to expect that you make the minimum while you maintain a new normal. Because that's money that you could be giving to your spouse or your kids, not necessarily Citibank. So there's other considerations, but this is a great place to start getting your budget together that you're going to need and working with your legal team on it. So next thing about finances as a basic, how much money do you make? Do you know? I mean, a lot of people, their money just hits direct deposit and they might know, but they don't really know what their deductions are, or they really haven't worried about that, or their spouse and both your incomes go in there and you just don't really pay a lot of attention. But figure it out. What is your income? What was your adjusted gross income on your tax return last year? Did you get a raise this year? Is it going to continue? Are you anticipating needing new career training if you've been out of the workforce and you need to go back to work? If so, what do you need to do for that? Are you going to need to get a certificate? You need to go back to college? Like, what are the costs of the education that you're going to need? And is your income going to stay the same? Are you happy and stable where you are, or are you looking for another job? All those things are going to be important. Another thing I'm going to touch on really briefly now is insurance. We talked about insurance a little bit earlier, but a lot of people have home and auto insurance, and there's also medical insurance. And so you need to know what are all the policies, who is covered by what, and what is helpful. Connecting with an insurance broker to actually understand what your options are is something most people never do. They just call up, I don't know, they go online to eSurance or Geico, or they call up State Farm and they just deal with somebody there. An insurance broker actually doesn't charge you anything at all. It's a free service. And what you can do with that is, get like access to a bunch of different insurance companies, and have an idea of what might be the best option for you. And there's no charge to do that. And it's a great way to have different options looked at when you're figuring out your insurance budget, but it's super important. Medical insurance is probably also a major financial concern for you during what's already an uncertain time. You should rest assured that no changes can be made during your case. So, and you can't just drop someone off of medical insurance. Most of the time, your employer and that policy won't allow it until you have a final divorce order or it's open enrollment. But at the end of the day, temporary financial restraints are in place in cases that happen as soon as the case is filed in King and Snohomish counties, that says you cannot make changes to insurance. So if you're on insurance while the case is going on and you're on your spouse's insurance and you're going to come off of it, you're not going to come off of it until the case is over. But it's a really good idea to shop around and figure out, can I get coverage through my own employer? Or if I don't have an employer, how much is it going to cost me to buy a similar policy to what I have now? And there's ways that you can do that, but start thinking about that. Compare the cost of staying on COBRA to your existing insurance to buying your own policy. Those things are really, really, really critical for you to know. So those are a few basics to think about before I get into some more family law specific things. So those all relate to your family law case, but those aren't necessarily the big primary issues. So Melissa, do we have any questions before I get into that?
Yeah, there are a couple of questions.
Sure.
I'm going to pull one from the chat here. What if the divorce is already finalized and you're a situation where your ex didn't show you or share any of the financial documents and gave it to the mediator without your review?
I don't really know. I can't give really specific advice on that without reviewing the documents, but I'll tell you this. I just finished a mediation yesterday, and a very standard provision in what are called CR2A agreements, which are settlement agreements, indicates that both parties have given full financial disclosure. And if you haven't given full financial disclosure, anything that you didn't disclose that's discovered later is typically divided. Every agreement's a little different, but my standard agreements are 75% to the person from whom it was hidden and 25% to the person who didn't disclose it. So that's an incentive to disclose everything. In this situation, if you're mediating, and I don't know if you have had counsel or not, but financials need to be provided in advance, because you can't get to a place of being well informed about your settlement options if you don't know what you're settling on. So financials are often provided to a mediator, but they're also provided to each of the parties. You should never, ever, ever finalize anything without full financial disclosure, because you may have signed something saying you had an opportunity to do it or get it. There's different ways to get financials in a case. If you're post-divorce and something wasn't disclosed, or you think you might need to enforce an agreement or anything like that, I would encourage you to do a specific consultation with someone to review your documents and your situation and see what options you have. I would also encourage you to do it as soon as possible, because some things, some claims can be time barred if you wait too long. I've had people come back and say, oh, this was last year and I didn't get a chance. And by then it's been too long. So you have to do like a vacate motion and try to vacate your decree or anything like that. So take action if you think something should have happened that didn't happen, but I can't really get into specifics, unfortunately, much more than that.
Thanks, Michelle. A couple more questions.
Sure.
Is there any special information needed if both parties are already retired?
Yeah, that's a great question. I was actually doing like I said, I had a case yesterday and we were dealing with retirement. Long-term marriages, or post, what we call sometimes now gray divorces, people that are in the like post-retirement as a term right now. It's important to evaluate Social Security benefits. So you'll each want to download your Social Security statements and see what your benefits are. You'll want to know when you and the other party are planning on drawing. You'll want to know, and this is very helpful sometimes to work. We often will work with the CDFA to look at what the retirement assets are and what that's expected to generate for the parties in retirement when we're dividing accounts. So we make sure that both people have access to, residual income post-divorce. Sometimes you'll be in a situation where one person has a pension, the other person does not, but there's assets that they can draw on. So you'll really want to work with your attorney and potentially a CDFA, if your attorney brings one in, to look at what assets are going to generate what post-retirement income for you, what the Social Security benefits are going to be. And that's going to be important in deciding how to divide the assets. So it's a little bit different set of an analysis if you're in retirement, because the assets that you have are going to need to sustain you. And you're going to want to make sure that someone's not taking all of the assets that can be accessed now with no taxable penalty, and other people are only someone else is only taking the taxable accounts. So you'll want to really get into that with an attorney and evaluate what your options are. But that's a great question. Thank you.
Another question here in the Q&A is alimony and child support always paid by the husband, even if his salary is low?
No, plenty of women pay alimony and child support, just as a heads up. It's a good question. I think a lot of people just assume that. No, definitely not. We'll get into this in a minute, because I'm about to talk about child support and alimony, but I'll give you a high-level overview really quickly. So child support is paid. Let's talk about child support first. That's fun. Child support is paid by the person who has less residential time to the person who has more. So child support in Washington is based on what we call a statutory scheme, which is actually really helpful, because it's one of the things where there's not a lot of what I call discretion, which means whatever the court feels like. Child support is based on a few things: the income of the parties. So you take party A and what their income is, and you take party B and what their income is. And then there is a formula, and it looks at the age of the children. So if you have a 10-year-old and a 13-year-old, and then it looks at the county they live in. So the calculation is going to be different for King County than it would be for Spokane County. So you put in income of the parties, age of the children, county they live in, and then there are allowable deductions for taxes, for retirement that can be made. And then we have basically what the net amount is. And then we figure out what each person's percentage of the child support obligation is based on this formula. And this all sounds really complicated, but that's why we have a program that does it. You should be doing these calculations on your own. Anyway, so then you have the child support numbers based on the formula. And let's say one parent makes 60% of the formula, the other person makes 40%. Those percentages are what's going to decide who pays what towards out-of-pocket expenses. And out-of-pocket expenses are things that are not covered by child support, like out-of-pocket medical, like a copay, like work-related daycare is usually the biggest expense, extracurriculars, soccer camp, things like that. But the actual child support transfer payment is what I think this person was asking about. And no, the husband doesn't always make it. How do you know who makes the child support transfer payment? That's the monthly payment. Well, you look at the two parties and you say, who has more residential nights during the year? During the month. The party that has more residential nights, who's the primary residential payment, they get their percentage of the child support to keep, and the person who is the one that has less nights pays that percentage of the child support number to the primary residential parent. Sometimes that's mom, sometimes that's dad. Sometimes there's two dads, sometimes there's two moms. It can look very different, but it's not based on the gender, it's based on who has the most time with the children. There can be reasons to deviate from that number. Since we're talking about child support, let's talk about that for a minute. You might have heard the term deviation. What does that mean? Well, it means there's a standard calculation according to that formula that I just told you about. And then if you're going to deviate up or down from there, and it's much more common to deviate down than it is up, but if you're going to deviate from that number, there needs to be a reason if you have an agreement. So it could either be, we just agree on this number and maybe I'm going to pay for more. I'm going to, get car insurance for the kid. And so I'm going to pay a little less in child support, whatever. There can be any number of reasons why you agree on it. Or sometimes I'll have a case where, I don't know, child support is $780 a month for the kids. And so that ends up being, I don't know, over $1,500, and the parties just agree on $1,500 or $1,600 or $1,200 or whatever. You can agree on a deviation, but the court has the final say on deviations. The court has a vested interest for the state in making sure your kid has the support that it needs. So some people want to know, can I agree to no child support? The answer to that is yes, but the court will need to see on child support worksheets that are done to support that calculation I just told you about. They'll need to see that there's sufficient resources in each household to take care of the child. So if there's no child support transfer payment for some reason, the court will have the final say on whether that's okay. Next thing to know that I think is very important about deviations really is if you have an equal parenting time, or if you have, let's say you have week on, week off, or whatever, you have a 50-50 plan of some kind, or let's say you have a plan where one party has 60%, the other party has 40, pretty close, right? So time with the child can be a reason to deviate. If you both have similar incomes and you both have the child, 50-50, it would be reasonable in that instance to deviate to no child support. However, if you're on a 50-50 plan and one party makes $200,000 a year and one party makes $50,000 a year, probably wouldn't be reasonable to have a deviation. And in that case, the party that makes more would pay support because it would be a hardship to the other parent not to get it. And you want to have financial resources in both homes. So there's a lot of different specifics surrounding deviations. It can be by agreement. When it comes down to asking the court for a deviation, there are factors the court can consider, like I said, more time with the child, whether or not it's a hardship. There's a number of things. So deviations can either be agreed or awarded. They're not very often awarded. Let's just put it that way. Another reason that you could do it is if you have children that you're paying support to from another relationship, that can be a reason to deviate from the standard calculation. It used to be called the whole family formula deviation. Now it's called something different, but anyway, that exists. Going above the standard calculation by agreement is not totally uncommon, but going above the standard calculation by having it awarded is uncommon. And there would need to be like a reason that, sometimes it's extreme medical situation and one party has the ability to pay and the other party doesn't, to provide more support if there needs to be in-home care, or maybe it's just sharing those expenses, but upward deviations are far less common. Anyway, that's something though that can be done. When it comes to another question about child support that comes up a ton is, what if I have a new partner or a new spouse? Is their income considered in child support? And the answer to that is mostly no. So you can't obligate a new spouse to be part of the child support, calculation at all. However, the income of a new spouse does need to be disclosed, and it can be a reason to deny a deviation. So let's say parent A got remarried and someone's looking to adjust child support, or parent A has a new partner and the divorce isn't final or whatever. So parent A is saying, hey, I have a 50-50 parenting plan and we make the same amount of money, so I don't want to have to pay support. I can't pay support. And parent B is going to say, well, wait a second, you have two incomes in your household. You're definitely in a position to pay support. So that can be a reason to deny a deviation by the court. So it doesn't factor into the number, but it can be a reason to say that your house has more or less resources. So that's something that's important to know. Another thing about child support is that you really, really should know is even if someone doesn't make a lot of money, it doesn't mean they can't pay child support. That amount, which kind of relates to the question earlier, that amount of child support, there's a minimum is $50 a child that the court's going to expect you to pay. But you also too, if you're voluntarily underemployed, being what I would call underemployed, like maybe you just work part-time for some reason, you're going to be imputed to full-time wages. Or if you're not working at all, the court's going to impute you and expect reasonably that you could make this imputed number a month if you were working in a very base level job. So that's something to know as well. You can't just say, hey, I can't work, I can't afford support. There's going to be an expectation that you do pay support, even if your income is imputed. So that's very important for you to know. And again, this is a high level overview of things. So if you have more questions, you'll want to discuss it specifically as it relates to your situation with an attorney, because I can't really address everybody's different scenarios, but it is important to know that income can be imputed. And sometimes people just pay the minimum if for whatever reason that's agreed, or they can't pay any more than that at the time. Child support can also be adjusted every 2 years. So what I mean by that is adjusted based on what current income is. Every 2 years, you have an option to go back and adjust the income to update the child support transfer payment and to also adjust what the proportional share payments are. So that's totally something you can do. Child support can be modified at any time based on a substantial change in circumstances. So if you lost your job and you can't make that payment anymore, or it needs to be changed, losing your job is a substantial change that wasn't contemplated when you entered the order. So you might be able to change things sooner than 2 years. Or if you want to make any other changes to your child support order other than just the amount of the payment and the proportional share, in that case, then what you would want to do is seek a modification if you want to change who's claiming the kids on taxes, or whether you're splitting things 50-50 and not using proportional share. All of that is going to need to be factored in. So anyway, that's a bunch of information about child support. Melissa, do you have any other questions before I move on to talk about spousal support?
I think we're pretty caught up right now. So just a reminder to attendees, if you do want to ask questions, go ahead and pop those into the Q&A or the chat. Otherwise, we'll just keep delivering information.
Great. Okay. So someone asked also earlier in that question, the next topic I was going to discuss is alimony. We don't use the term alimony in Washington, so you might not hear that term. You might hear the term spousal maintenance or spousal support instead. Spousal maintenance is the Washington term for alimony. It's a little more of a friendly term. I like to say that Washington uses more friendly terms than not. So anyway, what I mean by that is we don't talk about custody. We don't have custody orders. We have parenting plans. We don't talk about alimony. We have spousal maintenance. So we don't have a custody schedule. We have a residential schedule. So a little friendlier terms. Anyway, spousal maintenance or spousal support is the Washington term for alimony. What does that mean? It can mean two things. Traditionally, it means payments from one party to the other post-divorce for support. Pretty simple. It can also be temporary support, payment from one party to the other on a temporary basis while the case is pending, temporary support. So how do you determine who's getting it, how much it is, any of that kind of stuff? This comes up and is a very hot button issue in divorce, and it is the biggest thing where there is the most discretion. So what I mean by discretion is the court can do kind of whatever it feels is right. There are basic guidelines, and there is some case law on spousal maintenance, but it's very discretionary. So a court, you could go into 5 different courtrooms. I always visualize a hallway, and I think that's what it looks like at the courthouse, even though we don't go there anymore. We do it on Zoom. But you could go in there and see 5 different rooms, go in with the same case and get 5 different answers on spousal maintenance, and they'd all have a way under Washington law to be right. So when I tell you that, not to tell you that there's no idea what's going to happen, but to tell you that it can vary. And so you take a risk anytime you go to court. So what we generally try to do is negotiate spousal maintenance in a manner that's reflective of Washington law. We look at what factors are considered. We look at the income of the parties. We look at the length of the marriage, and we look at what people's position is going to be going forward. So is it a short-term marriage? Is it a midterm marriage? Or is it a long-term marriage? That's extremely important when talking about spousal maintenance. A short-term marriage in Washington is typically anything that's 5 years or less. And the court in Washington has a policy to essentially look backward. So the goal of a short-term marriage ending is to put the parties in the position that they started in. It's not to have one party living the same lifestyle they were living during the marriage if that's not how they were living before. It's not to do, it's not to, allow someone to rehabilitate themselves. It's really just to put the parties back where they were when they started. So spousal maintenance is very often not awarded post-divorce in a short-term marriage. Maybe in a 5-year marriage, you might get 1 year, unless there's specific circumstances. But short-term marriages, and I'll break down kind of a years of marriage to maintenance ratio in a few minutes, but short-term marriages as a public policy are backward-looking. Now, I'll talk about long-term marriages, and I'll come back to midterm marriages. Long-term marriages in Washington are traditionally 25 years or more. There's case law that talks about equalizing parties moving forward, and that can depend on a number of things. The essentially age of the parties. Sometimes people will be married 25 years or more, and they're not even close to retirement age because they got married young. That situation is going to be different, and the court's going to examine more about your working years than if you have a long-term marriage where the parties are both retirement age. Totally different. So that's important to know as well. But long-term marriages, the goal of the courts is generally, I say generally because like I said, there's exceptions based on age and circumstance, but is generally to equalize the parties moving forward. So that would mean parties should have the same amount of discretionary income every month. So maintenance from one party might be paid to the other. If one party has a pension and Social Security benefits of $3,500 a month, and the other party's on SSDI making $1,800 a month, so party A is going to equalize party B with spousal maintenance moving forward because it's a long-term marriage and they should both have the same amount of money. So also too, in longer term marriages where one party is still working, maintenance is very common. And again, I'll talk about the ratios in a few minutes. Midterm marriages, this is where it gets fun. Most people's marriages fall into the midterm marriage category because it's a big range. It's really like 6 years on up to the 20s. And that's a huge range, right? So if it's a shorter midterm marriage, it looks different than if it's a longer midterm marriage. But generally speaking, there's the most discretion and most flexibility here. So spousal maintenance is generally awarded, and I like to say this depending on if I'm representing the person that's paying it or the person that's receiving it, somewhere between a 3 and 4 to 1 year ratio. So 3 years of marriage could be 1 year of maintenance, 4 years of marriage could be 1 year of maintenance. So obviously if I'm representing the person that's paying it, I'm like, oh, it's always a 4 to 1 ratio, right? If I'm representing the person that's receiving it, 3 to 1, or if it's a really extreme situation, maybe even less than that. Bottom line is it goes back to what I said earlier, there's discretion, but 3 to 4 years to 1 is a pretty standard range. So you kind of have a range of risk of what it might be. So 20-year marriage on a 4 to 1 ratio, you're looking at about 5 years. 20-year marriage on a 3 to 1 ratio, you're obviously looking at more. So your answer probably lies on what it would be somewhere in between. So that's what you need to know. There's a lot of room for negotiation and what the court can do. And is there always going to be maintenance in a case? No. If the parties make about the same amount of money, or if one party has sufficient resources to sustain themselves, even if don't make quite as much, there might not be maintenance. There also might not be maintenance if you're looking at what we call a disproportionate division of the assets. I'm going to talk about the assets in a few minutes. But if you're dividing assets and you're giving somebody more, so you're not making monthly payment to them when you otherwise would, that can be another way to deal with it. A lot of times people just don't want to have to deal with getting monthly payments from their spouse. So midterm marriages, lots of discretions. Midterm marriage is where you often see rehabilitation come into. So if you had someone that was a stay-at-home parent and they need to go back to school and complete a program to be able to be self-sustaining, they might receive maintenance that's rehabilitative in nature to allow them to do that. So anyway, a lot of information there about maintenance. Melissa, I see, looks like there's a couple questions. Yep. You want to shoot those my way?
There's another question here. How does abuse, whether it be financial manipulation or psychological abuse, come into play in divorce?
Oh, that's a good question. I could do a whole webinar on that alone. But what I will say today, since we're talking about finances, is that we're a no-fault state. So when I say that, it means that you can't be allocated, we talk about this in almost every mediation too, you can't be allocated more money if there was physical abuse or someone cheated or anything like that. So that's important for you to know. If someone used community resources on something that was non-community, so if someone had an affair and spent a ton of money, and it usually has to be a lot, but let's say they spent a bunch of money on the affair, obviously they spent community money on a non-community purpose, that could be called community waste. Or if someone spent it on their gambling and you didn't know about it, that could be community waste. So that is something that could change allocation of funds. But if someone is, a lot of people will say that they're victims of what's called coercive control or other psychological abuse or manipulation, you're not going to get any more money for that. I think the question is just going to become, is that something that's going to impact parenting, where it needs to become relevant for that reason? Is it something where you feel like, domestic violence has been committed against you and you might need to get a protection order to keep yourself safe? So all of those things, moving forward are definitely things that could be addressed. So, but anyway, you're not going to get more money because those things happen unless there's actually been waste. So hopefully that's helpful. Other thing, Melissa, are we ready to move on? Or not yet?
Move forward.
All right, great. Other thing I wanted to make sure that we cover is the division of debts and assets, because this is a huge financial question for people. Most people are thinking, gosh, what's going to happen here? How much money am I going to walk away with? Are they going to, is my spouse going to take my entire 401k? Like what's going to go down here? So if you're on this webinar, maybe you've looked into divorce or family law a bit and you've heard the term community property. Well, that's the big term, right? So Washington is a community property state. What does that mean? Let's talk about what that means. First thing that you do, and you say, what is community property? Well, community property is anything, and I'm going to make sure that this is clear. It's any assets, but also any debts. So any assets that are acquired during the community period are going to be presumed to be community. So first thing I do, and I used to do this when I met with people in person, I would like to draw a circle and say, here's where your community started on this end. Let's say your community started when you got married in 2004. Here's where your community ended down here at the other side of the circle in 2022. So everything between here and here goes into the circle. So you've got your house in here, you've got 401k, you've got an investment account, you've got that Robinhood account you set up online that has 50 bucks in it, whatever. You've got everything in there, right? You've got your wages, everything. Doesn't matter whose name is on it. There's a presumption that that is in the community. And then what you do is you start looking at backing things out of the community, taking them out of the circle. So what comes out of the community? First thing that might come out is inheritance. If one party got inheritance during that time and they kept it in an account in their own name, there's a presumption that that's going to be separate property. Let's say you got a gift from your parents and you got that, like, let's say you got a really expensive watch or something, gift was an antique or something. And, that's going to come out of there and be your separate property. So, or let's say you got income that was derived from a business that you had before the community began, that's going to be separate property too. So first thing we do is we figure out what's the community period. Second thing we do is we figure out what's in the community. What are all the assets that are in the community? Third thing we do, and this is the kicker, we figure out how do we divide it. So just because we're a community property state, it literally does not mean that we are a 50-50 state. Some states that are community property, namely California, which is a huge state, and it's a 50-50 state. So no matter how long you were married, no matter how much money you make, your stuff's going to be divided 50-50, that's community. Washington, that's not the case. Washington, we are what's called a just and equitable state. For example, I just settled a case where the property division was 53-47. That's very normal in a Washington case, or maybe it's even 60-40, or sometimes maybe it is 50-50. Short-term marriages, it's pretty common for it to be 50-50 because it's backward looking, like I said earlier, putting people back where they started and nobody really profiting from, more than the other because we're not looking forward. But our standard is not 50-50. So what is it? It's called just and equitable. What that means is Washington law says that community property will be divided on just and equitable lines. So what does that mean? It means what's fair. And that's so funny. Funny, not funny, haha, but kind of funny, ironic, because what is fair is not an easy thing to answer and is not the same to everyone. I always tell my clients, there's like really one thing that's fair. And it's basically like the fare that happens every year at the Puyallup or whatever, or it's what you pay on the bus. There's no fair. No one's going to think that one answer is universally fair. But there are certain ways that a just and equitable resolution is determined. And the court tries to figure out what's fair. They really do try. Or if you're in a mediation, you really do try to figure out what's fair based on what's likely to happen in court. So again, we go back to short-term, midterm, or long-term marriage. Okay. Next thing we do is we look at not only short-term, midterm, or long-term marriage, but we look at the financial situation of the parties at the time that you're exiting the marriage. What are your incomes? And then we look at the history of the marriage. Did somebody stay home to take care of kids and sacrifice their career? What is it looking like? And why would somebody get more of the community? Well, typically the less moneyed spouse, the person who's not exiting the marriage with the same higher income, or who hasn't been working, is going to take more of the community because they're not going to recover financially as fast from the divorce. If somebody's making $70,000 a year and the other person's making $300,000 a year, that $300,000 a year earner is going to go out next year and continue to replace income and assets. The $70,000 is going to be spending down their community assets right away. So in a midterm marriage, it's not going to make sense for assets to have to be spent down right away. So maybe when that person walks away with 60%, maybe the other person walks away with 40. I mean, those are just some scenarios. So anyway, what's the community? How long is it? What's in it? And how's it divided? That's all stuff we need to know. Same with debts. Student loans, are those, that's a whole other question we could get into, but we don't have a ton of time. So Melissa, are there any other questions? I'm going to move on to another
Yes,
issue.
I've actually gotten several questions here, so I have a few more to ask. Okay, so you're talking about community property. Are the community property rules and dividing assets the same in a CIR case as a divorce case?
We're about to talk about CIRs. So you jumped the gun for me. That's good. Yes and no. So it's still the same question about what is the community period? And in a CIR case, I'll define that in a minute for you, anybody who doesn't know. What's in a CIR case? So what's the community period? And the time frame can be a little more questionable there. And a CIR period can also be tacked onto a marriage. So that's another good thing to know. But how those assets are divided is somewhat similar. You're still looking at the just and equitable standard. You still need to figure out what's the community period, what are the community assets, and how are they divided? In a CIR case, I would say the main differences are there's way more arguments about typically when it started and when it ended. So that's something to know. And also too, with student loans and things like that, if you have a loan and it's like at the end of a marriage or a CIR and somebody went back and got an MBA, well, even though it's during the marriage or the CIR, it's likely that the person who got the loan and got the degree is going to keep that loan, and it's not going to be community because the other party is never going to benefit from you getting that degree. But in a CIR, committed intimate relationship is what a CIR is. Washington recognizes unmarried couples in committed intimate relationships for purposes of dividing community property and debt. So it's still just an equitable standard. Debts are still divided, but in a committed intimate relationship, you might not have a disproportionate division instead of spousal maintenance because spousal maintenance is not available in a committed intimate relationship. That's a big difference. Attorney fees are also not available in a committed intimate relationship. And where they are on a need and ability to pay standard in a marriage. So those are some significant differences. Determining whether you have a committed intimate relationship can be somewhat tricky. Adding committed intimate relationship time on is usually pretty fair game if you then got married and stayed married for a while. So let's say you got married in 2006, started living together in 2004. Division of the community is probably going to start with that 2004 date for that CIR time. You never got married, and it's just what I would call a standalone CIR case with no marriage attached, it can be a lot more contentious of, well, when did the marriage really become serious? When did, when did the continuous cohabitation start? When did the other party get rid of their apartment? So determining what that window of time looks like can be different, but dividing the assets, it's still community division along just and equitable lines. So hopefully that was helpful.
A couple more here. So right now the real estate market is insane with houses selling for hundreds of thousands over listing and appraisal.
Indeed.
My husband wants to pay me on appraisal, but houses in our area are going for $500 a square foot. Can I force him to sell so that I can get the maximum amount?
Maybe. I would say, here's the thing. If your husband wants to keep the house and buy it out and keep it, you're gonna have to agree on a value. An appraisal value is typically going to be lower than you're going to get in this market. I think we all know that. That's just reality. Yeah. So what I would do is I would get an attorney, because let me give you an example. This is a good example. Settled a case recently where someone was trying to do it by themselves, and the big issue was the value of the home. One party had an appraisal, and the appraisal used to be kind of the gold standard for what was used in court. as far as what the court would accept. Other party had a couple CMAs, which are comparative market analysis, that said the house was worth a lot more. So essentially, that party, there was a big discrepancy. And then yet another that other person was still saying too, well, look at these Zillow and Redfin values. These tell me what the house is worth. So 3 different answers, all tens of thousands of dollars apart, right? So what it really came down to in that case was settling on the appraisal value would have shortchanged the person being bought out significantly, which it sounds like is what you're talking about. So what we did in that case is we were able to present a scenario that showed a big difference in value and asked for the court to accept the CMA values. And so we actually had a realtor provide testimony about the market and CMA values, and the court actually accepted the CMA values ahead of the appraisal value, which was pretty huge. Anyway, so bottom line is it can be a big difference. What you really want to do is support your position. And the other thing to keep in mind, I just discussed this actually yesterday, is we were talking about a house out on the peninsula in this particular case. And this is a small house. And one party was saying, oh, well, it's worth $680. And the other party's like, no, it's worth $725. Well, the party keeping the house, if you're keeping the house, nobody's paying cost of sale. If you guys are selling the house, the court will estimate about 10% for cost of sale. So if we take that $725 price or $750 price or whatever, and we figure out 10%, you're looking at taking about $75,000 off of the total that everybody's going to get anyway, right? So then you're really still back around that $66,000, $67,000, $68,000 mark. Excuse me. So too much talking today. So anyway, long story short is forcing someone to sell. Hang on. Sorry about that. Forcing someone to sell is not as easy as you might think. If one party can support that they can keep the house and make the payments and afford to buy you out, a court is sometimes hesitant to force the home to be sold. But if you're in a trial setting, the court might force them to be force the home to be sold if there's sufficient assets to equalize you. So it depends on if you're talking about settling this in mediation or settling this at trial. If you're talking about settling it at trial, you want to have somebody that can testify about the home selling for a lot more. And then you want the court to adopt your value and order the home sold, which could happen. If you're at mediation, you want to get multiple values, try to support what the home is worth, and try to negotiate either a home sale. But you want to take into consideration that you're looking at having to share in cost of sale. You will have to share in about a 10% cost of sale. You'll have to share in any repairs to get the house ready. So figuring out whether we're talking about going a couple hundred over listing is a big difference than just going 50 over listing. So anyway, okay, that specific situation, but we do deal with this all the time. So your questions are good ones. Anything else?
Yeah. So if we're paying child support and providing for other kids as well, does the child support change or get reduced if I'm paying for also housing, utilities, and insurance? Like it's kind of what you were talking about before about the adjustments that need to get made to take into account all the
No, I mean, if you're paying for like your utilities and your housing, no, child support is meant to cover food, shelter, basics, and utilities. So for your child. So if you're paying for those things, you don't get to deduct those. I mean, everybody has those expenses is what the court considers. So you don't get to deduct those and then come up with your net income amount. You really only deductions allowed are taxes, medical insurance if you're paying that portion of the premium for the child, and an allowable retirement deduction. So if you're paying for other kids, though, if you're paying for a child from another marriage, that might be a reason to ask for a deduction from your support. So if you're paying, child support for another marriage, or you have another child in the home that you're supporting, those could be reasons to seek a deduction. So that's a great question. Okay. So we only have like 5 more minutes. So if there's nothing else, I will wrap up. But if there are any, let me know, Melissa.
I've got a couple of questions. So maybe we'll try to just go through those real fast.
As fast as we can. I'm happy to do it.
Okay. If you sort of mentioned earlier gifts and community separate property, if his parents gifted money to pay for the house, does that count as community or separate?
Depends on who he gifted it to. Did they gift it to both of you? This is a big, I had a case I went to trial on this a couple of years ago. If they gift it to both of you, if they gifted it to both of you, it's community. If they gifted it to one of you and there's a gift letter or it's very clear through some writing, then it's separate property. So it's really not up for debate. How it's presented and the evidence that you have, or if someone will testify about the gift and that's credible, is really important. But if they gifted it to both of you, it's community. If they gifted it to one of you, it's not. That's kind of a general rule.
Okay. We're going to ask one last question and then we're going to have to wrap up. Any recommendations on how to handle an opposing party, both the client and the attorney, who are extremely aggressive and racking up additional conflict, unnecessary orders, opening civil cases, etc., in order to increase attorney fees in a CIR?
Yeah, sure. I don't mean to laugh about that, but it sounds like somebody I know. Anyway, a lot of people, attorneys do that, unfortunately. A lot of time, if you have somebody that's super, that's their personality, they'll find an attorney that also practices that way. Best thing I can tell you is get someone that's familiar with that. Get someone that will try to neutralize and not play into that, and may be able to seek sanctions if there are repeated claims that are not going anywhere or that are not relevant. But sometimes, unfortunately, you get people that are really abusive litigants. And so what you need to do is get your own attorney that can help neutralize that and understands those kinds of personalities. If you're dealing with it on your own, document everything. That's the best advice I can give you. Don't have communications with that attorney or the other party on the phone, only have them in writing, like email. I can't stress that enough to you. So, and also good luck. I mean, it can be a really stressful situation. So I feel for you if you're going through that. So it was great to have everybody here today. Hope this was helpful to you. I could talk about financials again, but I feel like we covered a lot of good things today. We covered child support, we covered spousal maintenance, we covered division of debts and assets and community property. We also covered budgeting. We covered some other hot button issues like insurance, something you might not have thought about that you need to deal with. And we covered, again, at the outset, the financial documents that you'll want to get together when you start a case. So a lot of good information. I hope this was useful, like I said, and I appreciate all your great questions, because your questions really, you might think it's just a question for you, but it answers a question that a lot of other people probably have too. So thanks for coming. I hope you have a fantastic day, and we'll see you next time.
Yeah, just to add, I put up here the contact slide. If you have really specific questions about your situation, please do call for a consultation. I put my information here too if you're interested in counseling services, but in particular, if you have questions about really specific financial issues as they pertain to your separation or divorce, call Michelle or call another attorney's office to make sure that you get a full consultation and get all of your questions answered. We do these webinars fairly frequently, and both Michelle and I are also part of a larger group that does a meetup once a month. So we hope to see you at one of those very soon. I'll leave this up here for just a moment so that you can copy down information if you'd like to. And again, thank you for coming.